everyone. This is attorney Arkady Frekhtman, a New York City personal injury trial attorney. And today we're doing a new series about large multi-million-dollar verdicts all across the United States. In 2022, this year, there have been so many large verdicts. And by large, I mean anywhere from, let's say, 10 million all the way through over 200 million. And that was a toxic tort case. So today I wanted to talk about a case that was a verdict of about $60 million. It was a premises liability case. And it wasn't a typical case the way you would think, like of a dangerous condition or of a horrible ceiling collapse or deck collapse where many people got hurt. This was a little bit of a different case. It involved a hotel and a couple, a husband and wife, who were a little bit older. And what happened was they planned to take a trip and they planned to go to a resort. And the wife had to go first for whatever reason. I think the husband had to stay at home a few hours away because they had a business where they took care of dogs and they bred these dogs. And so he had to stay to maybe take care of one of the dogs. And so she went ahead. And what happened was she was in the hotel by herself at 6:30 p.m. and she suffered a brain aneurysm. And what that means is that one of the blood vessels in the brain just kind of bubbled up and it became almost like a balloon, and then it ruptured and then the blood started flowing out. And what happens there is you can have something known as hydrocephalus, where there's a lot of pressure on the brain. So that's something that really has to be dealt with right away. And so the husband and the wife had this policy where, they would just call each other. That was just their custom and practice. They would call each other every few hours. So he called, and obviously he couldn't reach her. So when he couldn't reach her, he called the hotel and he said, please do a safety check. And they sent a maintenance man to do a safety check. And the maintenance man just kind of opened the door and he looked inside and he yelled out, like, anyone here, anyone here? And then he closed the door. He didn't do the correct safety check according to the policy and procedure of the hotel. So she was left there, and she remained there from 6:30 p.m. when it happened all the way until 5:30 a.m. the next morning, when her husband finally came in with a representative from the hotel, and they found her laying on the floor. She was still alive, but by that point, the hydrocephalus and the brain bleed got so bad that now she has this horrific brain injury where she cannot remember anything like longer than 5 minutes. So she, for example, wakes up every morning and she thinks that she has to go to her job, but she's retired. She hasn't worked at that job in 20 years. And her husband actually has to drive her sometimes to the job just to calm her down. So it's a really horrific, like life-altering brain injury, and she's going to need extensive care for it. But it was a tough case, because the defendants were offering very little money, and at one point, the plaintiff actually made an offer of settlement, and he said, look, I'm going to settle the case for $10 million, and that was 5 years before. And the defendants said, no, we're not going to accept that. So now, because at trial, the plaintiff beat that offer, he ended up getting a verdict of $60 million. And so because he beat that offer, they have to pay 10% interest for 5 years. And, 10% of 60 million is 6 million times 5. That's 30 million extra dollars. And the entire judgment is now $90 million, which is a tremendous judgment. And of course, it's probably going to go up on appeal. So we'll see what happens. But this is in a West Coast. This is, I believe, in California. So perhaps it could, still be a very high judgment. So yeah, so basically, I have the trial transcripts and I went through them. I didn't read everything, but I was just interested in this case because it's a little bit different. So I read through some of the trial transcripts. And I think one of the issues that I noticed in the voir dire was that the plaintiff's attorney was just being very honest, right? And very open with the facts. And he wasn't really blaming any of the potential jurors, because there were a lot of jurors, right? And all the jurors were listening to this. And many of the jurors didn't like the fact that the husband didn't go right away. They said, well, look, it's the husband's fault. If the husband calls and she doesn't answer and he's worried, well, why didn't he go right away? Where was the husband? But they had a good answer to that, because what had happened is the husband gave his cell phone to his wife. I think his wife's phone broke and he gave her his cell phone. So he didn't have a cell phone and he was maybe like 4 hours away. So he figured, I'm going to stay at home by the phone, because if she calls me, I don't know why she's not calling me, but if she does call me, well, I'm here by the phone, and that's how she could reach me. If I start driving, well, then she can't reach me at all. So that was one of the things. But what he really did was he just kind of listened to the jurors, and he said, look, if that's how you feel, if you would blame the husband, that's fine. But if that's your true feeling, then perhaps you can't be fair on this case. And they agreed. They said, yeah, I can't be fair because I've already made up my mind. So he got all of those jurors off for what's known as cause. And then the only remaining jurors were jurors that could be fair, right? And another thing that he did that was very interesting was that during the trial, he really focused on the policies and procedures of this hotel. I believe it was called Diamond Resorts. And so they recently bought this hotel, but they didn't spend any time training the team members, the staff, into their policies and procedures. And one of the policies and procedures that they had was that for any kind of welfare check, right? If somebody says, look, I need you to check on a customer, somebody is having a potential issue, maybe they're hurt, I need you to do a safety or welfare check in room 123. The policy was, the way to do that is to send 2 people, right? They knock on the door, they go in, and both people are there, they're witnesses, and they check the entire room, right? Every nook and cranny. They check the bathroom, they check everything to make sure it's really safe, the person's not there, and then they get back to you. But that wasn't followed. You see, what happened was when he called, I believe the customer service representative at the front desk was just getting off a call with another customer. And then it just happened that the maintenance man was standing there because he had been done fixing something in another room. He was going to report to her. So she goes, okay, why don't you go to room 123 and do a safety check? And so she violated that policy and procedure. And that's where the maintenance man just kind of walked in. He's like, is everything okay in here? Okay, so I guess everything's okay. And he just leaves. And he doesn't even go into the room, right? He just stays by the door. And he said he was embarrassed. He didn't know, right? She could be having, she could be naked. She could be having someone else in there. They could be doing some kind of, having intimate relations. He doesn't know. But that's not the policy and procedure. So a lot of what he did on direct with that maintenance man, as well as with the person in charge, the supervisor, was the lawyer just kind of asked, look, is safety your number one priority? And they say, yes, of course, safety has to be our number one priority. Okay, so if safety is your number one priority, then don't you have to be proactive? Don't you have to take measures? Like, you have this policy and procedure. Why do you have this policy and procedure? Tell me why you have it. What's the intent of it? What's the purpose of it? And then they would explain what the purpose is. Okay, so if you're going to have this policy and procedure, don't you have to enforce it? Don't you have to make sure that it's being followed? Where's any proof that you trained anybody on it? Do you have a checklist? Do you have a log? They don't have anything, right? They're very, they don't know. They say, yeah, we have this procedure, but it's almost like, okay, I'm going to have a procedure. I'm going to write it down in a book somewhere. I'm going to put the book away in a dusty drawer, and I'm never going to follow the procedure. So what's the point of the procedures? That was kind of like what the plaintiff's attorney was saying, and it was a powerful argument. And we have some of the actual transcripts, and you could see here I highlighted some of them. I was reading through it. I think it's a good template for any type of premises liability case. Some of these questions can be used for any kind of case. It's really good. And the fact that this guy says, I don't know, it really hurts them because they were not proactive. They didn't take care of the issue. So that was basically the case. And so now, because of this severe injury, right, you can't have any memories. So that was the issue in the case. Number one was the issue of liability, right? Who's at fault? Are they at fault for not doing the safety check properly? Because if they would have done the safety check properly, well, then they would have found her, right? But what difference would that have made? Then it gets into a medical issue. And each side, I believe, had two or three medical experts. And so what the plaintiff's experts said was that it would make a difference because, look, if she's there from 6:30 p.m. and all night, like many, many hours, that's the hydrocephalus, that's the pressure on the brain, that's what caused her to have this horrific, permanent, inability to have any memories and just this permanent brain injury. If this would have been found quickly, like within an hour, well, then it would have been resolved. And the defendant said, no, it happened right when it happened. This was a serious injury. It just happened right away. Even if it would have been found earlier, she still would have had this injury. But I think the evidence was just overwhelming, and the plaintiff's attorney did a really good job. And the jurors believed that it was, in fact, and I think that is true with strokes, with injuries like this, minutes really matter. And here, from 6:30 p.m. all the way to 5:30 a.m. the next morning, that's a very long time. And if he called right around 6:30, 7 p.m. So if they would have done the proper safety check and found her, they could have called the hospital, gotten her to the emergency room. They would have nipped this in the bud. She might have had some small residuals, but nothing like this. So then the verdict was for future care, the cost of future care, it was $9.5 million. And for the past pain and suffering, it was $12 million. And for the future pain and suffering, it was $29 million. So for a total of $41 million. And then it was, like we said, $9.5 million for the future care that she's going to need. And then $10 million as a loss of consortium for the husband. $5 million past and $5 million future. Now that is how the husband was hurt in having now to nurse and care for his wife and losing his wife because this is such a traumatic, horrific injury. But, remember, back to voir dire, those jurors that were going to blame the husband, they would never have given $10 million to the husband, right? So that was very smart. And a lot of the times you can use loss of consortium to get rid of bad jurors. So that was really smart. And then, like we talked about, the fact that they had that offer to settle for $10 million, which was rejected by the defense. Well, now with interest, that becomes $30 million, 5 years of interest at 10% per year. So the total judgment is $90 million. So an amazing result, a very serious injury, but I would say this is a difficult case. This is not, a very simple case. And a lot of people would have strong feelings about a case like this. And there were a lot of other issues that I didn't go into in this video. Like there was the issue of whether this entire complex was a timeshare versus a hotel, because they had owned a timeshare there, but the same procedures applied, so the same policies and procedures. So I thought it was, I thought this was a very interesting case, and very congratulations to the attorney that did this case. And I thought it was really, really smart. And, I like the fact that he actually sent me the trial transcripts. So I was able to read them. It wasn't a recorded. Some trials get recorded on CBN, so you could actually watch the trial. This one was not recorded, but we have the transcripts. And I think it's helpful, especially that first witness that he called. By the way, what he did was when he opened up his case, a lot of lawyers, when they start their case, they're going to call the plaintiff first. What he did was he called the defense witness, and he actually called the witness who was the supervisor, I believe, that was enforcing all these procedures. And he really, questioned him and made it seem like, look, you have these procedures, how come you don't follow them? And I thought it was very, very persuasive. So actually a lot of those questions can be applied to any type of premises case, any type of case where you have policies, procedures, manuals, guidelines. So that's one of the ways that a plaintiff's attorney can show that the resort, like a multi-million dollar, billion-dollar resort, they have policies and procedures, they have knowledge and control, but they choose for whatever reason, either they're negligent or maybe they're just lazy, but they're choosing not to follow them. And that's why the procedures were made, to prevent this type of harm. So that's clear liability. And that's what I think, that's how he won this case, even though, it was a little bit of a difficult case. A lot of people will say, look, lady got hurt in her hotel room, accidents happen and it's not worth anything. So he was also very smart to get all those jurors off for cause. Okay, so I hope this has been helpful. Let us know what questions you have. Please like and subscribe to our channel. Please ask us questions and leave us comments, because we're also doing the other series, which is answering your questions once a week. But this new series is going to be talking about all types of serious, high-value verdicts and settlements. Some are going to be from New York, some are going to be from all over the country, and I'm going to do like a 10 to 15 minute deep dive into these cases and tell you about them, tell you about the verdicts, because right now there are a lot of high verdicts that I'm seeing, and it's almost amazing. There was a verdict for a wrongful death for 20 million, another wrongful death for 33 million, a motorcycle crash, 36 million. This case was 60 million, actually 90 million with the interest. There was a case with a serious paralysis for 100 million. There was one, a class action for 102 million. There was one, I believe, I have to get the details, but it was 150 million. And then there was a case, like a toxic tort type case for 275 million. So a lot of really big verdicts happening right now after the COVID pandemic and trials opening up and a lot of trials happening. So I wanted to cover some of this and see what the themes are in these high multi-million-dollar results and let you guys know so you could share your thoughts. Okay, have a great day, everyone. Talk to you soon. Bye-bye.